Good morning, Mr. Maidman.
Good morning. If it pleases the Court. Stephen Maidman for Joseph M. Garuti, the defendant in this case. Your Honors, I'd like to address the ineffective assistance of counsel issues primarily in my argument today. In particular, I'd like to begin by focusing on what I think is the most important issue in the case, and that's the failure of defense counsel to provide me with an affidavit and provide the defendant with an affidavit. I requested an affidavit in conjunction with a motion for new trial, which was filed by the defendant in this case. I specifically asked for a affidavit. I provided a draft affidavit. This is actually all in my affidavit. This is all in the record. And essentially I was turned down.
Well, he said he couldn't sign the affidavit you had presented.
He did say that.
Didn't he say that?
In one sense, he did say that. But I gave him the opportunity to make any change he wanted in that affidavit. He could have rewritten it, could have done anything he wanted with it, consistent with the truth.
Well, isn't that, isn't it implicit he couldn't sign it because it wasn't accurate?
Well, he could have given me an affidavit, and I could have made the decision whether to use it or not use it. And as a result of that, an adverse inference was drawn against the defendant by the trial judge. Of course, in the same paragraph, she said there was no obligation that she knew of to provide an affidavit in the first place. And this is an issue in Massachusetts. It comes up repeatedly from a defense standpoint. The trial judge wants an affidavit from the defense lawyer to know what happened. And invariably, case after case, the case law is replete with this, you don't get an affidavit. And right now, and Judge Giles was correct when she said she was aware of no precedent, at least in Massachusetts. And I'm not aware of any precedent anywhere in the country for that matter, quite frankly.
Mr. Maidman, be careful what you ask for. If the evidence is, I asked for an affidavit, I got an affidavit, but I decided not to use the affidavit.
Justice Marshall, the facts are what the facts are going to be. In this particular case, I think the evidence is overwhelming, at least on the defendant's affidavit, that this was constitutionally incompetent representation.
You know, I read that affidavit, and I'm not so persuaded that it is. Tell me why. That he didn't do a complete mock cross a direct examination. He only did a partial one.
No,
is this the kind of stuff you're talking about?
Your Honor, let's start from the beginning. The fundamental problem was it was an inadequate consultation with the defendant. Now,
whatever that means. I mean, I don't know how many times you're supposed to meet with him to have adequate. He says he wasn't adequately consulted with, but what does that mean?
That means talking to the defendant and finding out his version of the incident.
Oh, he was never interviewed. He was never interviewed?
Well,
I thought he was
I won't say he
several
was never.
times.
I can't say he was never interviewed. I don't believe that's correct. The question is, what is the extent of consultation? This is a factually complex case. I mean, it may appear on its face.
Well, you say it's complicated. We know that the victim was struck by his truck while he was picking up his kids while they were.
And he would say to you, it was an accident.
Yeah, I understand.
Well, help us to articulate what you claim should be the standard as to when an attorney falls below that which is constitutionally required of counsel because he failed to communicate adequately with his client. What would you say is the standard that we should apply here?
Well, there's at least one national standard, and that's the ABA standards on criminal justice, which require consultation. Now, is it flushed out? How many telephone calls does he have to take? How many meetings does he have to do? Obviously, it depends on the facts of each particular case. But he at least has to sit down and understand the facts from the defendant's point of view. In this particular case, it's clear if you look at what's in his affidavit and then you compare the cross-examination, Attorney Krowski could have done wonders with some of those facts.
Like what?
Wait, which one?
How about the fact that you had a interrogation that probably went well beyond what was appropriate by one of the troopers in terms of getting right in his face, right up to his nose.
Okay, so isn't it true you got right up into my client's face? No.
No, he could deny it. I mean,
But you're saying, but I thought what you meant when you said he could make wonders of the facts, that we've got a variety of sources of evidence that this was not an accident. Your client says it is an accident. What about the facts of what happened there on the driveway? Could Mr. Krosky have dealt with in some other way?
I think that if he had consulted with the defendant, knew his version of the incident, he would have brought, and the defendant had testified, which is we haven't gotten to yet.
Right.
It would have painted a very, very different picture. And more than that, it would have raised reasonable doubt. It would have raised reasonable doubt. Now, part of the problem was he didn't consult with him adequately, okay, which led to the fact that he wasn't prepared to testify, which led to the fact that he could not make an intelligent decision whether or not to testify. I mean, it just goes step after step after step. And the problem with this case is that you have a barren evidentiary record. We don't know what Attorney Krosky did or didn't do. As we stand here today, I mean, I can speculate. I can certainly speculate.
You know, it's one thing to say, I gave my attorney a lot of information about witnesses that could have testified to that things happened differently, and my attorney never contacted them, did anything in that regard. It's another thing to say, you know, he didn't extensively practice my testimony with me. He didn't really give me the kind of information I would have liked to have had. He didn't speak to me as much. He didn't answer all of my letters. I mean, that every case, are we going to in every case have defense counsel come in and go through the file and do an extensive memo? What I did with the defendant over the last 3 years. Is that what we want? Is that what is necessary for us to make a decision about ineffective assistance of counsel?
I don't know if that's necessary in every case, but I would suggest to the court in this particular case that defense counsel, because of the lack of consultation, was inadequately prepared at trial. And I don't know how else to say that.
So what you're looking for, I guess, from Attorney Krosky is I spent 20 hours consulting with my client in the following days, and in my view, that was sufficient.
What I would have asked from Attorney Krosky, he had a copy. Well, I'm not sure it's in the record. I would ask him to take a look at the defendant's affidavit and tell me what isn't true, and more importantly, tell me what is true.
Mr. Maidman, this Attorney Krosky represented this defendant at trial. Do you really think it's reasonable to think that the attorney, having done that, is going to file an affidavit saying my client is lying when he says X, Y, and Z? I mean, it's just.
He doesn't have to file. He has to give me the affidavit. I will make the decision whether to file the affidavit. And if I just determine, which is part of the defense function. I mean, I
mean, I just think it calls into question a fair amount of issues about that attorney-client relationship that he had, where it's going to go with respect to the Board of Bar Overseers. I mean, I just think that's not realistic to think that an attorney's going to do that. Maybe as part of my analysis of the case, maybe I would decide not to file the motion for new trial. Maybe I would conclude that the defendant is not entitled. Maybe I would make the recommendation, be specific at least in the Massachusetts context, maybe I would recommend to the Committee for Public Counsel Services that I'm not filing a motion for new trial in this first-degree murder case. But at least I have to make the assessment, the professional judgment, whether there is such a case. And based on the record that's available to me and the record that's available to this court, the record, it's just not there.
Could we just turn to the question of, I mean, your client's affidavit was very clear that he made the decision not to testify. As I understand it, it was essentially, had I known the full range of options, I would have reached a different conclusion. Do we know what was available to the Commonwealth about your client's relationship with his former wife, or something that would have been used to decimate him or to attack him on cross-examination?
I think they had pretty good material to decimate him. In terms of the relationship, they introduced a 5-year-old restraining order. They had witnesses coming back from Christmas of 1999.
So your point is all of that was coming in, and they
it was all in there,
and they didn't hear another side of the story.
Well, that's right. I mean, this is really a defense failure. I mean, this wasn't fair. I mean, I don't want to make a 33E argument, but when I looked at this thing, you had this, just read the affidavit, go through this, and then you see what the trial looked like.
Well, did the
That's
judge?
not fair, Judge.
Did the judge have a colloquy with him about?
She certainly did.
And did the judge explain you have a right to testify? and-
Yes, all that. It was
All
a
of
good,
that.
good colloquy. Problem is that a colloquy presupposes a constitutionally competent lawyer who's explaining, well, you know, there's some strategic advantages to you testifying, especially if your story is never going to get into the record.
But I gather you're not saying here that an effective counsel could not have come to the view that the better course was to keep him off the stand. Or are you saying that that an effective counsel would certainly have had him testify here?
I think I would let the defendant make a knowing and intelligent decision, assessing, you know, all this stuff that you say happened. You're the only person alive left who could testify to this. Other than the state troopers, who else is going to contradict the state troopers as to what you did and did not say?
Right,
I'm sorry.
But I assume that's what Judge Giles told him. I assume that
No,
part of
I
the
don't-
colloquy was that, well, I mean, I assume he knew that there's only certain things that he could testify to since there was nobody else there except for the wife who's dead.
Whether that was made explicit by Attorney Krauske, if you believe the defendant's, certainly reasonable inference from the defendant's affidavit is that didn't happen. And that's a problem. I mean, we had lots of colloquy.
Is a problem, but I mean, I take it the colloquy took place when? After the Commonwealth's case?
Yes.
So I assume that the defendant knew if he didn't testify to things that only he knew, of course it wasn't going to get into evidence. How is that supposed to happen? I mean, that's the whole nature of the decision. I mean, that's,
Your Honor,
if I don't testify, then no one's going to have my side of the story. There are upsides and downsides to this. It seems to me that, according to your own client, he explained to me what the downsides would be, advised me not to testify, but told me it was my decision, and it was my decision, and I understood that, and I had a full colloquy, and now I wish I had.
unfortunately, we don't know what was said and what was not said by defense counsel.
So what's the rule that you would?
Just before you, excuse me, why do you not know that? Because your client can tell you.
Oh, I know what's in the affidavit, but I don't know what Attorney Krauske would say.
No, I understand that, but your client is the one who had the preparation for the colloquy with Mr. Klawski, so your client can tell you what he told him. Anyway,
I mean,
I didn't mean to cut you off. Just
That's okay. I was just wondering, how would you describe the rule that you'd like us to have that would flow from this case if we agree with you? That in all cases going forward, upon a request for an affidavit from appellate counsel, a lawyer is obligated to review any submitted affidavits and address whether each aspect of the affidavit is true or not true.
I certainly think that would advance the Sixth Amendment interests, and it would certainly advance the Article 12 interests. I think that's excellent. That would be fine. I think they have an obligation. Well, first of all, under the CPCS performance standards, are obligated to cooperate. It's not that explicit whether they got to provide an affidavit. I would suggest they have to provide the affidavit upon request, consistent with the truth, and then defense counsel can decide whether or not to use it. And as a result of that, he may decide not to bring the motion to a trial in the first place. I think this is a critical issue under Massachusetts law. You have case after case where it's duly noted, and I put in my affidavit, it's conspicuously missing. I think I used those words. The affidavit was conspicuously missing.
I take it that we could ask, I take it that you would have no objection if you had a conversation with trial counsel and then decided that, you don't have to have it in an affidavit.
Right. I'd have to have here's part of the problem. The problem with just merely having a conversation, and I had a conversation with Attorney Krauske, at least prior to all this. A conversation is not a sworn affidavit. And more than that, I asked, Mr. Garuti's affidavit was very, very specific about how many letters I wrote, how many phone calls. I mean, this is a sad story, Your Honor.
No, I understand that. When Justice Ireland was articulating what you were asking for, I mean, presumably, if you had a conversation with defense counsel and decided that based on what defense counsel told you, represented to you, you were not going to press for a motion for a new trial. You wouldn't want us to say you have to put that in an affidavit.
Right, but maybe not. But on the other hand, I might want an affidavit to lock him into a story and to make sure it's done under oath. So I know, other than just Joe Garuti, he would have done terrible on the stand because he'd be saying bad things about Shirley Garuti. I mean, that's essentially what's in the record as it stands right now. But I don't know specifically what, for example, the best example. I mean, I send him a draft affidavit, 6 pages. I mean, I thought it was a fair affidavit. And I get back one line saying, I can't sign it because it's inaccurate. To this day, I don't know what's inaccurate about it. It's not in the record.
All right, so the attorney submits an affidavit. Obviously, this is going to take a tremendous amount of time. I'm sure you realize how many ineffective assistance of counsel claims are made on appeal or motions for a new trial. They're countless at this point because the door has been opened. And an affidavit saying, I don't remember much about the case, but I certainly would have spoken to my client extensively from time to time when I met him, or sufficiently. So you say, all right, now we got to have an evidentiary hearing, because, or the attorney says that simply isn't the way things happen, and says something different than the defendant. Well, now we have to have an evidentiary hearing. We need people under oath now. So let's move to the next step. We have contradictory affidavits. Let's get them in. Is that the next step in this? Is how it's going to work?
Corey, maybe we do need, even in the situation you're describing. I mean, we're dealing with a first-degree murder case. Maybe that's what's necessary to vindicate Sixth Amendment interests. I think that's...
We look at the trial performance. I mean, it is... I mean, we have lots of things to look at. We can look at the trial performance, and surely, and the fact that there was a colloquy here on the most important issue, which is whether he was going to testify and tell his story. There's a colloquy that helps us there a lot. And this isn't a case where the client is saying, I gave the lawyer a whole bunch of investigative leads that would have resulted in alibi witnesses, and my lawyer didn't follow it, on which point, I mean, that's just a very different kind of case.
Right.
And you might proceed in that case a little differently.
But certainly the reasonable inferences from the defendant's affidavit is that he gave him plenty of material relating to the cross-examination, relating to the incident itself, which he could have used. And it didn't happen.
Those are kinds of sort of judgment issues at trial. Not investigating a whole line of defense is really of a different order. I mean, it just seems to me. The only I would suggest that to a certain extent it's a quality control issue. I mean, what level of quality do we want from defense counsel in a first-degree murder case, or in any case in Massachusetts? And I don't think it's going to open the floodgates of evidentiary hearings. I think a lot of them are going to get filtered out. I would suggest to the court that this is what, if we're going to have a motion for new trial, at a minimum, I think it's a real problem for a trial judge in this state to say, well, I didn't get the quote-unquote, use the word, confirming affidavit, and then the rest of the paragraphs that say, well, of course, there's no obligation to provide a confirming affidavit. That's a problem. That's a problem for defense counsel statewide. I see that as a potential problem in a number of cases. I agree with you. The fact that a judge will say, well, there's no affidavit from counsel, and the other side says, well, they wouldn't give me an affidavit. That's kind of a... I need an affidavit.
And then you draw a negative inference.
And then you draw a negative inference. I don't disagree with you that that's a bit of a conundrum.
I would close by... I'm sorry.
No, I'm not sure how to resolve that.
Yeah. I mean, it's what is the quality of defense representation we want in the state? And the only way you're going to find out is by getting either evidentiary hearings, affidavits, something, to determine what the facts are. And right now, the Commonwealth in its brief talked about an abuse of discretion. Well, yeah, I would suggest it's an abuse of discretion. But the real question is, was there a substantial likelihood of miscarriage of justice? And I would suggest that's certainly an open question as we stand here today. And unless the court has any further questions, I rest on my brief.
Thank you, Mr. Maidman. Good morning, Mr. O'Connell.
Morning, Your Honor. May it please the Court. Michael O'Connell, Assistant District Attorney for the Commonwealth. I would suggest all of what you have just discussed with the defense attorney is belied by the trial record. All you have to do is look at the trial to see the performance of Mr. Krowski in this case. Now, there's a assertion here that he should have provided an affidavit, and he's put between a rock and a hard place if he does. He either signs the affidavit saying essentially I was committed malpractice and I was ineffective, or comes up with another one and says my client was lying. That's not a choice the defense attorney should have to make, and I don't think there's any authority that indicates they should have to make it, and I don't think it should be created, because that's not an issue.
Let me ask you this, and defendant comes in afterwards, motion for new trial, puts out an affidavit. I gave my lawyer all of this information about how to find the witnesses that were there at the time, and my lawyer didn't do anything about it. And so it's a different case than this. It's not like he didn't talk to me as much as I would have liked to, or he didn't answer my letters, but it's a case about whether the lawyer pursued a very important lead, and whether the defendant provided. So counsel can't get an affidavit from the lawyer about any of this. Forget about it. I'm not giving you an affidavit. I don't remember. Well, I'm not giving you an affidavit. Judge gets the defendant's affidavit with all this information, says, that's very interesting. Where's the lawyer's affidavit? Oh, you don't have a lawyer's affidavit? I'm sure you've taken the position on a number of occasions. Your office says, hey, there's no lawyer's affidavit in this case. You know, how can?
Well, Your Honor,
how has he met his burden without a lawyer's affidavit?
I have to analogize this. This is kind of like answering an essay question in a college exam. There are technical things like rules of evidence that we have to follow, but largely this is a matter of art. The defense or the prosecution of a case at trial is a matter of art as well as technical ability. So
I used to try cases.
Well, I understand
I used
that.
to think so.
But if a defense attorney has to explain himself explicitly in a sworn affidavit every time he tries a case, that's going to put a pretty big chill on the artistic aspect of this skill. And I think part of what you're saying, at least part of what I'm hearing, is that there are different circumstances. A lot of them may fall into this art versus quantity. But do you think it would be appropriate for judges to say, I really need to hear from the attorney here? The judges should be alerted to that, and then say have an evidentiary hearing or require an affidavit or something? Well, Your Honor, on a case-by-case basis, yes, obviously. There are going to be instances when an inquiry would have to be made, but I don't think it's here. Because Judge Giles didn't base it just on the lack of an affidavit. She based it on the performance that she saw.
Mr. O'Connell, let me ask please finish, I'm sorry.
I'm sorry, that's pretty much it.
Sure. I mean, taken at face value, and I haven't read the whole transcript, but, I mean, you make a very strong case in your brief. And then you read the affidavit. I mean, if the claim here is accident, which what was the strongest piece that defense counsel used to show that this was an accident?
Well, there were two strong showings here. One is the cross-examination of the pathologist, Dr. Zane, who's been mentioned before. And the second one is the cross-examination.
And that was the weight of the vehicle and the bones hadn't been crushed and so on and so forth.
And the nature of the injuries and whether or not a certain bone was easily broken or not. And also the cross-examination of Sergeant Sullivan, the accident reconstructionist, who testified as to the evidence that was left in the driveway that was part of the trial. Those are the two longest cross-examinations in the trial by anybody. And, of course, I didn't cross-examine anybody.
So, for example, with respect to Sergeant Sullivan, was there cross-examination about whether there were braking, tire things that would indicate?
Deceleration, yes, Your Honor.
Yeah, so that kind of thing.
Yes, Your Honor. And many of the technical aspects of her examination were questioned and essentially quibbled with by the defense attorney on the cross-examination, trying to create, if you will, a doubt that what she said was true. And the same thing goes with The pathologist, again, it wasn't the pathologist who performed the autopsy, it was a substitute because the other fellow was out of the jurisdiction. But again, quibbling with the aspects of the injuries, claiming that if she had been run over by a 2-ton vehicle, her bones would have been crushed, there would have been tire marks on her, et cetera, et cetera. I think all of that goes to preparation by the defense attorney. He knew what he was doing when he started this trial.
No, of course he did on cross-examination. Here's what's somewhat intriguing about this. Of course, I'm not going to go into the pros and cons of whether somebody does or doesn't get called to testify, because those are often tactical. But frequently, it seems to me that the facts around what happened in this case were essentially confined to the relationship between the defendant and his former wife and the events that happened that evening. This is not a man, as I understand it, who had a prior criminal record. This is not a man who was in any of his other relationships involved in any tension or difficulties. I mean, it wasn't that he was, rolling from employer to employer or something like that.
No, there was no evidence of that, Your Honor.
Correct. So you really have the classic, as it were, confrontation, limited in scope, which, as you can hear from the 2 other cases this morning, you can see the difference.
Yes.
Lots of reasons, why you don't put somebody on the stand. Here the defense is accident, and the jury is going to get a great deal of information, and did get a great deal of information about the very, very negative relationship, and indeed abusive, if the jury believes the restraining order, between the defendants. So they have plenty of evidence of anger, hate, perhaps. And there's no counter to that. And they have really, the cross-examination may indeed have been effective of the 2 experts, but sort of missing is, well then, if it didn't happen that way, what way did it happen? And I think that's the point of Mr. Maidman's, that's, as I understood, the thrust of it, which is, this is, of all the cases that I have looked at where there's a tactical decision not to call the defendant, almost all of them, you can just see up and down the problems that are going to happen. Or you don't call the psychiatrist, you can see up and down. In the earlier case, the problems that are going to happen. It's very hard to see up and down in this case what the risk was.
Well, I think to a certain extent you can rely on the defendant's affidavit as to what the defense attorney said about that. And that is backed up by what happened not only during the investigation, but also what happened with the other evidence that we provided as to the relationship. And that is, when it came to his former wife, this individual was loud, profane, and very quick to anger. And I would suggest to you there's a severe danger that that's going to come out on the stand.
Hadn't that come out?
Of course it had come out. But the fact of seeing it in the courtroom, I would suggest, would be highly dramatic and would, in a sense, compound the Commonwealth's case, make it stronger by showing that in this particular aspect of his life, he was out of control. And I can't see that how that could have helped him. What he said and what his defense was this was an accident. That was before the court, because that's what Attorney Krowski's defense was. It was argued. It was the point of the cross-examination of all of the witnesses. The allegations that the defense attorney made in his closing that the police were not being truthful went in that direction as well. I don't see how the possibility that he might explode on the stand when I'm cross-examining him about his relationship with this woman is going to help him. I mean, the defense is there, and the defense is before the jury, and it's their function to weigh the evidence. And, of course, there is no witness other than the defendant because there was nobody else there other than the 2 children inside.
Did the kids testify at all?
Yes, Your Honor.
They talked about what occurred between the defendant and his ex-wife before they went back into the house?
No, because they were not there when the ex-wife was talking to the
I
defendant.
thought the daughter came out, talked to him. He talked about, get your stuff, they talked about that?
Well, she came out, and then she went back in.
Right.
Then the son came out, and the son went back in. And that's when the ex-wife came out. So when she came out, they were both still in the house.
And so no one heard the exchange?
Exactly.
I see.
Exactly.
And then they talked about hearing the tire screech, or one of them did, right?
Both of them did, Your Honor.
Both.
Both of them indicated tire screeching, and that's obviously goes to the evidence of the tire marks in the driveway that led up toward the house, up the hill, up toward the house, as opposed to down toward the street. And my argument, obviously this is a case where extreme atrocity or cruelty was found, but my argument was also premeditation, and that, I would suggest, goes to premeditation. There was a photograph that showed the tire marks
But the,
going up to the house.
Was there a view?
Yes, Your
Is there videotape in evidence?
Honor. I
Do you
don't
happen
believe
to-
there was a videotape, Your Honor.
But they're tire marks, they're photographs.
There were photographs of the tire marks. Those the tire marks were no longer there during the view. The
No,
trial
of
was
course,
2
of
years
course,
after
of course.
the offense.
But the defendant's explanation of why the car went in that direction, I take it, is that he said that the wheels were still turned to the right because I backed up. That came in, yes?
Yes, yes, it did.
In what form did that come in? Oh, because he said that to the police?
He said it to the police, and his defense attorney during the trial got it from the police as well, that's what he said, and it was part of his statement to Trooper Lilly. I would just close with that particular issue and tell the court that it's the Commonwealth's view that, again, if you look at the trial transcript, you see the quality of the representation. The defendant is not entitled to perfect or brilliant representation. He's obviously not entitled to representation that gets him off. The fact that he's found guilty doesn't mean there was ineffective assistance to counsel. I would suggest, but what is required is adequate preparation and adequate tactical maneuvers to get to the goal, and I say that is belied. The defendant's claim that it was not done is belied by the trial transcript itself. Now, the other issues here, the second issue is waiver of testimony, and I just don't think there's any question that there was a colloquy. The defendant was fully advised of what his rights were. He was advised pointedly by Judge Giles that it was his decision alone, and not Attorney Krauski's decision as to whether or not he testify. And the defendant indicated, I understand that. I've been told that. In fact, during the colloquy, he asked to consult with his attorney, and he did. Judge went off the bench. There was a recess. There was consultation. When it was over, the colloquy resumed. There's just no issue here with regard to that. And as far as the other issues go, the evidentiary hearing on the motion for new trial, again, the denial was based upon the judge's recollections of the trial and her reading of the affidavit and not believing that it was necessarily truthful. She did not credit it. She didn't credit it because she was there. She saw what happened during the trial, and I would suggest that was a good basis for that. Unlike the Licata case where it isn't really said, but the Judge Liakos indicated that the motion for new trial was summarily denied. I take it that then there wasn't any findings and rulings of any nature, but here there were, and the judge was explicit in why she went the way she did. And those are the issues. The other issues, I think, take care of themselves unless the court has questions. The question of recording the interview with the defendant, of course, this was 6 months before the case came down, the D.G. Amatista case came down. Now the issue becomes what happens before and after the recording, and that's motions to suppress are based on that now, because our files are full of DVDs of statements of defendants. So there is no requirement, though, in that case that it should be recorded.
And the instruction was given in this case.
That's correct. The instruction was given.
I thought it was before the
It was, but you have to instruct.
The trial was afterwards.
You have to
the
instruct,
interior
even
issue
though
was
that.
Oh, the trial was after. I'm
Yes,
sorry.
the
I'm
trial
s-
was
I'm sorry.
afterwards, yes.
I was-
And if there are no more questions from the court, I will rest on my brief, and I would ask you to affirm the conviction and affirm the decision denying the motion for new trial.
Thank you, Mr. O'Connell. We'll take a short break.